please welcome Pete and Callum from Turcan Connell. Thank you very much, guys, for joining us today. And without further ado, I'll let you guys start off.
Not at all. Very happy to be here. Callum and I are going to speak a little today about trusts and planning for vulnerable, injured and disabled people. In the context of the work where we occasionally work closely with Digby Brown, there's a focus on personal injury trusts. Callum will come to that in a little bit more detail towards the end of the presentation. But that area of practice of personal injury trusts is part of a more global or wider practice area dealing with trusts for vulnerable people and disabled people. And it's an area that we do an increasing amount of work in. We do that work for our own clients. We're also introduced to work alongside other law firms that perhaps don't have that degree of specialism in the area. In doing so, we quite often operate on an assist basis, or are very happy to be referred work or introduced. Because obviously we share this status as part of the Digby Brown network, I would want to extend an open invitation to all of you at any point, should you have questions in this area, to pick up with either Callum or myself. Always happy to have a chat, and regardless of whether that leads to work for Turcan Connell. So what we're going to cover today is a little bit about the background to this, thinking about the client, the beneficiary, the end user, thinking about capacity, thinking about vulnerability, and thinking about disability and what each of these terms mean. Trusts as part of a wider support structure, and sometimes as a very important part of that wider support structure, but sometimes something that we're maybe not thinking about with immediacy, or perhaps we're just thinking about how proportionate trusts are to the type of problems that are being encountered by clients. We're going to touch on some relevant considerations in relation to planning for people with these profiles. Those relevant considerations are at the front of those relevant considerations. It's quite a wide topic in and of itself. Can be care profiles, benefits profiles, and benefits landscapes, and tax. And if we get to a point, I suppose, when we're advising injured people, incapable people, vulnerable, disabled people, where we think that that a trust should be part of their personal infrastructure, then we have to think about what it means to get that trust right. Trusts are very much bespoke planning vehicles. They should be mechanisms that help our clients better their position, improve their position. And because there are implications that come along with those implications, including cost, including to some extent freedom, and including tax, then we need to make sure that this kind of issue, this consideration of proportionality, is something that we think about with due rigour. And that should hopefully get us to a point where Callum at the end of the presentation is touching on some key planning questions for this type of work. And there will be an opportunity, as Stuart has said, to speak at the end and ask questions of us. We hope not to run on. Hope not to witter on. That's more likely to be me than Callum. But if you want to put your hand up, if you want to ask any questions during the presentation, please do feel free and able to do so. So we're touching on this, consider the beneficiary. What is capacity? And we're going to come to the kind of lion's share of this slide in a moment, but I think one thing to consider when we think about capacity and we talk about capacity is that capacity is a subspecies of vulnerability. It's an aspect of vulnerability. It is not in and of itself vulnerability. To be incapable is to imply vulnerability, but to be vulnerable does not imply incapacity. Incapacity is defined in terms of the Adults with Incapacity Act 2000 in terms of section 1 subsection 6, as being that an adult will be incapable of acting or making decisions, or communicating decisions, or understanding decisions, or retaining the memory of decisions by reason of mental disorder or of inability to communicate because of physical disability. And I'm kind of picking out the highlights there. And incapacity should be construed accordingly. And what does that tell us? That the word "or" there is highly instructive. That when we are thinking about whether a client or whether an individual is incapable, and capacity is very much task specific, so we're thinking in terms of the aspect that a client might be seeking to instruct us in respect of. And if the client essentially ticks one of those 5 A to E boxes, then for our purposes and for and in terms of the Adults with Incapacity Act, then that person may well be incapable, irrespective of the fact that for some of those other criteria, they will be fine or otherwise capable, and irrespective of the fact that they may well be entirely capable for other exercise of function. Callum, next slide, please. So again, an extension of this, what is capacity? As I've mentioned, capacity is task specific. So a person can be capable and incapable at the same time, but in relation to doing different things. A common example of this that we encounter in practice is where an injured person commonly, not exclusively, but an injured person commonly is instructing legal agents to conduct a litigation, and it is considered that that person lacks the capacity to conduct a sometimes complex litigation. Simultaneously, that person may have the capacity to operate their own bank account. So something relatively simple. So this idea of capacity, there's a complexity to it. It's not something that lends itself to binary judgment. Likewise, capacity can fluctuate day to day, it can fluctuate moment to moment. So a person can be capable and incapable on different days or at different times, but in relation to the same thing. Now there are plenty examples out there. I'm sure we will all have them as solicitors, of knowing that we have a client, or knowing that we have a former client that is incapable to an acute degree. But quite often that journey to incapacity is something that's subject to this idea of fluctuation, task specific narrative arc, if you like. And if we jump back to the last slide, Callum, this incapacity shall be construed accordingly. That right at the bottom there of section 1, subsection 6. What that clause tells us is that incapable means incapable of X, Y, and Z. But incapacity itself, beyond incapable means incapable of something, does not really provide us much more in the way of colour in respect of what a legal definition, certainly in terms of the Adults with Incapacity Act, of incapacity would be. If we jump back to the next slide, Cal. So that NHS guidance quote I've generally found quite useful, that capacity is the ability to use and understand information, to make a decision and communicate the decision made. And if we were to add a little edit there, we might say, and to retain the memory of same. And that ticks those boxes of A to E, and brings a little bit of definitive context to the definition under section 1 of the Act. Next slide, please, Cal. So why might capacity be important? Well, capacity is important for us as legal agents when it comes to understanding who our client is and from whom we can take instructions. Capacity has quite broad, or has broad is wrong. Capacity has several definitions in the law, but it might mean that somebody is incapable by dint of being a minor, a child. It may mean, and in terms of what we're largely going to talk about today, talking about somebody who lacks capacity due to mental impairment of some kind, largely. In which case we need to understand if we can take instructions from that person. And if we cannot take instructions from that person, then who is the person who is the intervener, the person who has the legal entitlement to step into that individual's shoes and to provide us with our instructions? And we've touched on the parent-child dynamic, but this can mean attorneys under a power of attorney. It can mean an intervener in terms of an intervention order. It can mean a guardian in terms of a guardianship order, and to some extent it can mean or can refer to curatorship under the oversight of the court. So understanding whether these further or different measures are and structures are needed for the beneficiary can be quite important in being able to understand and address issues of incapacity, identify incapacity when we see it is critically important when it comes to the work that we're doing in this area. It also lends itself to this question of if specific measures, if special measures are in place, then whom should settle the trust? Well, when we think about that question, we're probably usually thinking, is the injured party, the disabled party, the vulnerable party themselves in a position where they can settle a trust? And if that person can settle a trust, or even if that person's attorney or their guardian can settle a trust, then there are specific tax and care and benefits implications that attach to that, depending on the type of trust used. Personal injury trusts are kind of their own thing, and Callum will come to that later on. But when we're thinking about care and benefits, if an individual is settling a trust for themselves, or if that person's personal representative is settling a trust for them, then quite often the capital settlement of the trust will be considered to be a deprivation of assets, in which case that may not have any benefit, and it could have the opposite. It could have a negative effect on that person's care and benefits position. Trusts that are settled by a settler for the benefit of a settler also have very specific tax treatment applying. Whereas if we are dealing with, let's say, families who are affected by vulnerability and affected by disability, and their thought is beginning to turn to, should I make provision for my disabled child, my vulnerable child, for them in later life, then the position is different, because the beneficiary of the trust that they are going to be settling is generally speaking not going to be themselves. And likewise, unless the trust itself creates a beneficial entitlement in the hands of the disabled or vulnerable person, then there may be some, and more likely will be some advantages in terms of ensuring that support for care and benefits are not interfered with. So in terms of what the trust work, if indeed trust work is appropriate, might look like, then we think about this concept of mixed capacity, or capacity being task specific, the person having duality of capacity at the same time. And it may be that an individual has the capacity to determine for themselves that a trust will be settled and be settled for themselves, but they may not have the capacity to be a trustee. And that is quite important, a consideration, particularly around personal injury trusts, I would have to say, where we have to think about the capacity profile of individuals, whether it's the party themselves or a family member, as relates to specific functions. Yes, that specific function must be, is this somebody that can be a trustee? And we must consider what the drivers of time might be in relation to a family trust of any stripe, when it is tasked with managing for disabled or vulnerable people, or other people involved who are going to need additional support. That might be the beneficiary themselves. The beneficiary might be quite front and centre to the trust administration. So we need to think about what the implications there in terms of the cost profile of the trust, the risk profile of the trust, and those that I've mentioned defining roles there. Defining roles, there will be often in these circumstances guardians at the back, which can mean that trustees and guardians can act alongside one another, and in many cases, having that set up is both cost effective for the position as a whole, and can provide very useful checks and balances in relation to the trust practice and in relation to the guardianship practice. But as a generality to all of this, I think one of the kind of critical points that tends to be quite front and centre in our thinking is that people will come to us with the conclusion that they need, for example, a disabled person's trust because their child is disabled, or a vulnerable person's trust because their child is vulnerable. And they are ostensibly the same thing. But they'll come with that conclusion, and they might come with that conclusion when the person who would be the beneficiary of such a trust would be quite young. And we do, as advisors, in my opinion, need to think quite carefully about the cost profile, the complexity profile of introducing something like that, and to consider whether it's strictly necessary in the circumstances. It may be that we have a very supportive family dynamic where things are teed up quite nicely with mum and dad looking after the disabled child. There are siblings involved, and they're earmarked for a role going forward in relation to this. So quite often, in fact, always, we should be thinking in terms of, well, what is the right fit? And it could be that a lifetime trust, the disabled person's trust, is not the right fit at a point in time, but we ensure that wills are properly set up to facilitate that type of planning should it be needed. And we ensure that should something happen to mum and dad in terms of capacity, that the power to settle trusts a little bit further on down the line, where the longevity of the trust might be slightly less, and by extension the cost implications of the trust might be slightly less. And we just bring down this overall cost profile of whilst not losing sight of the fact that the right structure for the family remains absolutely paramount. Next slide, Cal. Thanks. So defining disabled is, I think, just quite an important or quite an interesting sidebar to this. Quite often when we are dealing with clients, we will be using the language of disabled persons trust, vulnerable persons trust, and that language can be quite loaded. And often we will couch it, and sometimes we'll couch it in terms of tax, because really when we're talking about it, certainly in terms of the Finance Act 2005, these trusts are tax mechanisms. So tax mechanisms for income tax, for inheritance tax, for capital gains tax. So that's something that we can use to our advantage. But it's also, I think, quite interesting to just touch on the differences in the definitions there. We've put up there the 2010 Act and the 2005 Act. The UNCRPD, which is referred to at the bottom, provides that disability is not viewed strictly as a medical issue. Instead, the UN recognises this social model of disability, that disability is largely caused by the physical, societal and attitudinal barriers that prevent an individual from participating equally. So there is a breadth to this definition which opens, or ought to open, our eyes to various considerations when we're thinking about the right type of planning for people in these circumstances and their families. Next slide, please, Cal. So trust is part of the wider planning structure, easy for me to say. Needs can be complex, and trusts don't answer every question. I touched on earlier on that quite often the dynamic, if there is a serious incapacity issue, can be that, and indeed if there is a need for a trust, and we think that there is a need for a trust, then quite often the trust sitting alongside guardianship provision provides good checks and balance for each role. But equally, a trust might not be the answer at all. There may be consideration of, what is the family's wealth profile, what is the family's family profile. Can we look at ensuring that there is this protection built in terms of getting wills right, in terms of getting powers of attorney right, in terms of thinking about planning not just for the vulnerable person at the heart of the family matter and at the heart of what would be a trust or might be a trust, but thinking about the planning as a family planning piece. And that is something that I find commonly comes to the fore when dealing with clients who are affected by disability, cerebral palsy, for example, where the capacity profile is often it's on a spectrum. It can be entirely changeable, and we're looking at not making any or introducing a great deal of complexity, but just building in protections that can be used over time and that will be responsive at such a time as a need will arise. But the planning piece goes a little bit beyond that. We want to think about things like pensions and life policies, particularly if at the front of our mind we have considerations around, well, what happens if this person receives a significant capital sum? Do they have the capacity to manage it? Well, no. Well, pensions and policies are areas where we can build in ahead of time. Trust planning and protection, which can align with wills and can align with powers of attorney and all of these types of things, to make sure that the structure is as complete and as cohesive as possible. But trusts absolutely should be part of the discussion and part of the consideration. It might be now, it might be further on down the line. We've got to think about protections for the beneficiary. We've got to think about the nature of a support structure, not just for the beneficiaries, but also for trustees, to provide there is a legislative background to this. There's a common law background to this that provides for the duties that trustees have to one another, the duties that trustees have to beneficiaries. There's a rigor and there's a diligence to the structure that ought to provide and can provide real comfort to families, particularly once they get used to what can be quite unfamiliar. And done right, it absolutely can have benefits and preserve entitlements to care and benefits entitlement that might be of real value to a person going forward. We need to be alive to the tax implications, and we need to be alive in particular to the tax implications of different types of structuring. And we need to consider, I think always need to consider this leading nature of the language of disabled persons trust and vulnerable persons trust, because it's not always going to be the right answer. They are, by their very nature, restrictive in their application. And that can provide that rigor, that comfort. But equally, if we're talking about bigger families and we're talking about the availability of flexibility, if we're thinking about, for example, a family that has a significant a parent with a significant death in service scheme entitlement, then the disabled persons trust might not be the right answer. Discretionary trusts available in these circumstances can be of huge benefit, and it should be viewed on a case-by-case basis and with the benefit of specialist advice. I think my last slide, Callum, maybe?
Yeah, I think so.
Yeah. So there's that might you want to take this one?
Yeah, all good. Hi everyone. So I'm going to focus in a bit more on trusts themselves and things that we really need to be thinking about as professional advisors when we're advising whether or not a trust might be appropriate. So I think as a starting point, on a high level basis, where is it that we see trusts for vulnerable people coming into the conversation? Well, usually it's when a sum of money has often been awarded, particularly in the context of personal injury trusts, or will be received by an individual, often by way of gift or inheritance. And there is concern around that individual holding those funds personally. So what is it that gives rise to those concerns? Well, there can be more general concerns around vulnerability generally and potential misappropriation of funds, or people who might be considered vulnerable being taken advantage of. But often more specifically, there can be concerns around the loss of benefits and care entitlements that might be means tested. With regard to means testing, it's quite easy to tip the balance in favour of means tested entitlements falling away. If we take the example of the likes of universal credit, if someone holds over £6,000, their entitlement to that will start to decrease, and if they hold over £16,000, then it'll disappear altogether. And care often assessed in a similar way, but slightly more nuanced. So trusts, are they a means of preserving those means tested entitlements? I think the answer to that is that they can be, but almost always depends on the circumstances that gave rise to the trust settlement. So in terms of the slide there, I've set out various examples of ways in which we commonly experience trusts coming to life, and I'll go through each of those. So the first is where a trust might be self-settled. So Pete touched on that, that's somebody essentially just putting money into a trust for the benefit of themselves. In terms of care and benefits, that is unlikely to be helpful in terms of preserving those, under the exception of personal injury trusts, which are subject to their own rules, and I'll come to later on. But generally speaking, a self-settled trust will, if funds are put into that to preserve care and benefits entitlements that are means tested, that will be deemed to be a deliberate deprivation of capital. I've mentioned tax at the top of this slide, and we'll come on to tax more broadly in the next couple of slides, but self-settled trusts are pretty much a non-event for tax purposes. A lot of the time, income is generally traced back to the settler. That might or might not be a problem depending on the marginal rate of tax of the settler, but it's unlikely to be particularly helpful. Will trusts are generally speaking, safer territory. If a trust is validly formed under a will, and that trust is discretionary in nature, and the beneficiary doesn't have a vested entitlement to the funds that will form part of that trust, then the funds in the trust should not form part of a care or benefits assessment. So that can be a properly structured will can be very helpful. Once funds are distributed out of the trust, then obviously they form part of the individual's assessment, but otherwise not. There's slightly more nuance where a will isn't framed appropriately, or where there's no will at all. If a cash sum is simply paid out to somebody absolutely, either under a will or in terms of the law of intestacy, then that money will be taken into account for benefits and care assessment. I suppose that the question that leads on to is can we do anything post-death if we come across a scenario where a will isn't framed appropriately, or there is an intestacy? And I think the answer to that is that we're in quite tricky territory at that point. And generally speaking, a deed of variation that redirects an absolute entitlement to cash to a trust will fall foul of deliberate deprivation rules. That being said, there are cases, not in Scotland but down south, which have looked at this, and slightly unhelpfully, the cases are conflicting, but there is reasoning which might provide us with some steer. The first case was that of LMS, and that was in respect of a young woman who had severe autism. Her grandfather had left her £170,000 in his will, and the terms of the will were that she would inherit absolutely at the age of 25. She was in receipt of means-tested support, and she was in receipt of means-tested care, which was very important to her, and included a college placement. Her mother applied to the Court of Protection in England to place the funds into a disabled person's trust, and that was actually allowed in that case. And the sort of driving factor in terms of coming to that decision was that it was proved that the testator's intention would have been for those funds to have been settled in trust rather than to have gone to the woman herself. That, as I say, it can be contrasted with the case of RE, F, and R. So that was slightly similar scenario in that there was a man in his 30s. He had a lifelong disability and was in receipt of means-tested benefits, and he came into a substantial inheritance of around £500,000. There was an application again made to the Court of Protection in England and Wales to redirect that inheritance to a trust, and the rationale behind that was to preserve his means-tested benefits entitlement. That variation wasn't allowed, and the reason was that the sole purpose was preservation of benefits, and there was little evidence to show that the testator intended for a trust to be formed. So I think it seems to be the case that it comes down to testator intention. The cases are obviously English, but rules around means testing and deprivation of capital are, I think, consistent across the borders, so it should carry some weight. But yeah, I think the overarching message is that we're in a tough spot, I suppose, if we are post-death and trying to do something at that point. Trust for minor children, that generally speaking, means testing won't come into it as much because children aren't often in receipt of means tested benefits. They may be in receipt of certain care, which might be relevant. In terms of tax, we have to be more wary here because any settlement by a parent for the benefit of their child could fall foul of settlements legislation, and income could be taxed at the marginal rate of the parent. And lifetime trusts for adult children, generally speaking, less pitfalls, but we need to be wary of the tax consequences of settlement, which I'll come on to. And trusts for vulnerable people, they're commonly administrative and not tax-led. That I think is true. They're often there to provide structures in which to manage funds and to protect the underlying beneficiary. And they are not often geared towards tax planning, but there are always tax implications of settlement, and it's very important to be wary of those before entering into any trust arrangement, and as well as the tax consequences of settlement itself. There is ongoing reporting and compliance obligations that need to be fulfilled by trustees. So in terms of if we've got to the point where we think a trust might be correct, which as Pete says, is a question in itself. Sometimes a trust isn't proportionate or necessary, and it'll be quite common for a client to come to us with a trust in mind, and the right solution is in fact something else. But if we do come to the conclusion that a trust is right, if somebody is qualifying as disabled in terms of the relevant legislation, does that mean a disabled person's trust is right? And I think the answer is no, not necessarily. Disabled persons trust, they're very useful in certain respects. They are discretionary in nature, so funds can be held at the discretion of trustees. They're subject to a different tax regime compared to that of normal discretionary trusts, and probably it's a more favourable tax regime that we don't have to worry about things that we have to worry about with discretionary trusts. But as Pete mentioned, we are significantly constrained in who can benefit from a disabled person's trust, and if there is an intention to benefit wider family, then it might be that a discretionary trust is a better fit than a disabled person's trust. It's also sometimes the case, and particularly in the context of personal injuries, that bare trust can be sufficient if all we're really looking to do is secure means-tested disregards. So in terms of tax, I don't have to go. I don't have time to go into the sort of granular detail of tax, but I'll go through it as best I can. In terms of inheritance tax, the disabled persons trusts, although they are discretionary, they're treated differently to a normal discretionary trust. Normal discretionary trusts being part of the relevant property regime, subject to entry charges to the extent that they exceed the nil rate band at a rate of 20%, and ongoing 10-year anniversary charges as well. Disabled persons trusts are not part of the relevant property regime. Any funds settled on disabled persons trust, it's treated as a pet rather than a chargeable lifetime transfer. So we're not constrained in the same way by the nil rate band. We can put as much into disabled persons trust as we want without incurring lifetime charges to inheritance tax. There's also no ongoing 10-year charges, which is helpful. The inheritance tax treatment is that when the vulnerable beneficiary dies, the trust is effectively accumulated with their own personal estate for inheritance tax purposes, and to the extent that the nil rate band is exceeded, inheritance tax might be payable at 40%. In terms of income and capital gains tax, discretionary trusts, as most people will be aware, are subject to higher rates of income and capital gains tax. That there are opportunities for tax reclaims where income is paid out to beneficiaries, but if nothing is done, tax will be charged at the highest marginal rate of tax. Trustees of disabled persons trusts, the default position is that they pay tax in the same way, but there is an option to make an election called a vulnerable persons election, and the effect of that is that trust income and gains are taxed at the marginal rate of the beneficiary. So that can be quite helpful, because usually, not always, but often the beneficiary will be someone who isn't otherwise in receipt of income. So we'll have the likes of full personal allowances available, and will often pay tax at lower rates. We've mentioned holdover relief. That's quite important. Holdover relief is very useful in the context of discretionary trusts. It allows us to get assets into the hands of trustees without crystallising any charge to tax. It's really a deferral mechanism, because the trustees receive that asset with the same base cost of the transferor. Holdover relief is not available where we're transferring assets into a disabled persons trust. So if there are assets that are intended to be transferred in, which are subject to substantial gains, then thought needs to be given to that. And if the trust is to be wound up in the future, again, holdover relief wouldn't be available on the way out. So we need to be wary of that. CGT uplift on death does apply to assets in a disabled persons trust. So anything owned by the trustees, when the beneficiary dies, it will be uplifted to date of death value. And we've mentioned property purchases because there is a bit of nuance in the LBTT and ADS treatment of these types of trust. LBTT, I mean, there's no way around LBTT. It's paid on all property purchases. The additional dwelling supplement was put in place to effectively as a charge on second homes. I think it's a flat rate of 8% at the moment. Trustees of discretionary trusts automatically opt into paying the additional dwelling supplement, so it can often be pretty punchy, even where there's a relatively low value property. Disabled persons trusts, for inheritance tax purposes, that there is a deemed interest in possession, and where there is an interest in possession in a trust, the ADS and LBTT treatment is often see through to that the person in respect of which the interest in possession is in favour. We've sort of considered this, and the consideration was, does this deemed interest in possession mean that the vulnerable beneficiary is treated as the purchaser for LBTT and ADS purposes? And where we've landed is that it needs to be more than that. That there needs to be an actual interest in possession granted by the trustees. So care needs to be taken, and if appropriate, an interest in possession might need to be granted to a beneficiary in advance of a property being purchased. So in terms of getting trusts right, should trusts happen now or later, or should they happen at all? As we've discussed, if there's a good support structure in place for a vulnerable person, that they're sort of catered for well by their family, and they don't have an imminent need for a substantial amount of cash, there's really an argument that a trust isn't required at all at that point. If we get to the point where we think a trust is helpful, and there's then the question of should we do that now, or should we do that later? And that will almost always come down to circumstances of the family and of the beneficiary. Tax is always a consideration as well. Trusts, we have to consider any tax charges on the way in to the trust, but there can also be tax efficiency that comes with trusts, disabled persons trusts and discretionary trusts, and that can extend beyond the beneficiary. For example, a settler transferring assets into the trust could get assets out with their estate for inheritance tax purposes, which might be good for the sort of family's overall wealth position, and there can also be income tax efficiency that comes with trusts as well. Sorry, but I'll also mention cost there, and again, cost just needs to be proportionate to whatever it needs to be proportionate to the value going into the trust. Really, we'll sometimes have clients coming to us looking to maybe make use of their annual gifting exemptions and thinking that trusts might be a good way to go about that. But it often the costs of establishing and administering a trust in those scenarios might outweigh the benefits. So we just need to take care to make sure we're leading clients down the right path. In terms of trustees, who should be the trustee, and again, but it can be obvious, but sometimes it isn't. If there's a supportive family and there's people that are involved in the day-to-day care of the beneficiary, then they are likely to be a good fit. The beneficiary themselves might want to be a trustee, and that can often work quite well, but also it can sometimes give everyone a bit of a headache down the line. And I'm sure that there's certain matters where Pete and I have acted, and in hindsight we might have pushed back a bit harder on beneficiaries acting as trustees. Ultimately, if a beneficiary has capacity and they want to act as trustee, we're all we can do is steer them in one direction or another. Family are often the go-to trustees, and they can be a great source of support, but they can also be some of the most problematic trustees, and we've seen families where money within a trust is viewed as family wealth, and that is just not the way these trusts operate. That they're there for a very specific purpose, and that's to benefit the vulnerable person. So care needs to be taken there. The role of a professional trustee can be invaluable where we think we might have a problematic board of trustees. It can provide some neutrality and a voice of reason. How many trustees? Again, it'll come down to circumstances. Trustees act by majority in Scotland, so we can default to 3, and that means that 2 can outvote 1, but it all comes down to the particular client and who is available to act as trustee and who might do that well. And what should the trustees hold? Again, that will come down to the individual needs of the beneficiary. It might be that they're holding property, it might be investments. Often, insofar as investments are concerned, there can be a slight discomfort compared to what we see with standard private clients. There can be an adverseness to risk, and we need to navigate that and make sure we're not pushing clients too hard. And appropriate financial advice is really important with that aspect of trust administration. So I wanted to come on to personal injury trusts. PI trusts, they are not all personal injury trusts are disabled persons trusts, and not all disabled persons trusts are personal injury trusts, but they are very much linked. A PI trust, it can be any type of trust, so it could be a disabled persons trust, it could be a bare trust, it could be a discretionary trust. What defines a personal injury trust is what it holds, which is the proceeds of funds received in consequence of injury, and who it holds those funds for, and that is an injured person. The benefit that we get from a personal injury trust is that funds in it are disregarded locations for the purpose of means-tested benefits and care assessment, and that applies even where a trust is self-settled. So that is quite different to the usual treatment of a trust, where a settlement of that nature would bring about the application of the deliberate deprivation of capital rules. There is a very specific carve-out insofar as personal injury trusts are concerned. And the rationale behind that is that somebody should not be prejudiced by the fact that they have received a front-loaded payment, essentially, or a back-loaded payment. Personal injury trusts, they don't have their own tax treatment. They are just treated in the same way as any other type of trust for tax purposes, but there is nuance in how they are administered. There's also often a requirement for a lot of money at the outset, where there's the likes of houses and potentially prosthetics, things like that being purchased. There might be a a significant requirement for capital in terms of care costs and appropriate financial planning to make sure that that is managed and funds are held back is really important. I've touched in this regards. The money is disregarded for benefits purposes. It's disregarded for residential care costs. Non-residential care costs are slightly different. Non-residential meaning care in the community. That often comes down to local authority view on trusts, which isn't particularly helpful. But generally speaking, a trust will be helpful even where care is being received in the community. Experience is a bit different. We're dealing with people who are often quite vulnerable and have received sometimes a 7-figure award, and managing them and making sure that the money is not being frittered away is as important as anything in the early stages, particularly, and getting the right advisors around the table is really important. And linked to that is we're often dealing with people in pretty difficult stages of life. They might have brain injuries. There can be a lot of sensitivity around what's happened to them. There can be volatility, and there can be things like addiction issues that we have to navigate, and we need to be appropriately sensitive around that, and we need to make sure we're seeking out the expertise of other professionals where relevant, and impose restrictions. So sometimes personal injury trusts come into being because insofar as the Criminal Injuries Compensation Authority is concerned, they often mandate that a trust is put in place prior to an award being made, and the Office of the Public Guardian will often I think QC our work where there's a trust being established for the benefit of someone who does not have capacity, and there's a guardianship order in place. So we just have to be wary of that. It can increase our time commitment where trusts are being formed, but generally speaking, they don't tend to make the wholesale changes to drafts. But yeah, we need to be wary of that. So finally, what are the key planning questions we need to be considering when recommending trusts? And I think, is a trust going to help the beneficiary now? We've touched on this throughout. We need to be thinking about that. We need to be thinking about cost effectiveness and the wider circumstances of the beneficiary. If they're well provided for at the moment, is there a requirement for a trust, or is there a simpler alternative? That all being said, settling a trust during lifetime can be a really good thing, even where there is a good support structure in place, because it can get a vulnerable person used to a trust structure while they still have those people that they rely on for their support around, and it can set them up well for later life. If a trust is the right answer, what type of trust will be appropriate? And that often, if someone's injured, that will often be a personal injury trust. And what type of trust beyond that is appropriate? It might be a disabled person's trust. It might, if there's an intention to benefit a broader class of beneficiary, then a discretionary structure might be appropriate as well. And how do we get the structure right? We need to be thinking carefully about trustees. We need to be making sure, insofar as we can, that any trustees have the beneficiary's interests at heart. Family members can be great, but they can also sometimes be a source of difficulty. And is a professional trustee appropriate? And what should the trust hold? Again, all down to individual circumstances of the beneficiary, and we need to make sure we appropriately navigate clients who are uncomfortable with risk and introduce appropriate advisors to help with that. And finally, this is one of the most important points, I think, it is the rest of the infrastructure and the right people in place. Trusts and legal advice are just one piece of the puzzle. Where there's vulnerability and where there's injury, there's often much more comprehensive requirements than that. And we've found the likes of case management to be invaluable. a good IFA who can pull together a good financial plan, provides steer to everyone, and it can provide a common goal. And beyond that, ensuring that there's appropriate social care in place and rehab services is all part of this as well. And if we as solicitors can tap into that expertise of other professionals in those fields, it almost invariably makes a better outcome for vulnerable clients, and particularly those with the most complex of needs. So that brings an end to our presentation. I think we've got some time for any questions. I know sometimes these forums aren't the best for asking questions, but either ask away now or you can pick up Pete or myself afterwards.
Yeah, we'll just give a few seconds in case anyone's typing a question in the question box there. But thank you very much, both of you, for coming along and presenting today. A lot of interesting insight there, and just thinking about trustees and trusts and the thought of including family and those things, and just thinking about myself, like it could be just. I know families can be incredibly complicated at the best of times, let alone when there's things like that involved. So I'm sure you've both had some pretty interesting discussions and situations around that, especially when there's vulnerable people involved. So thank you very much for the insight. We'll give everyone a couple of minutes in case anyone's hanging about for a question.
Yeah, I mean,
box and
what you said, Stuart's absolutely right. Families can be a material risk point for some of these trusts. Equally, they can be the guiding light of it. You've obviously advertised this as an update for 2026. I did turn my kind of mind earlier on to kind of what is the critical update for 2026. In terms of trust law, it's probably that the 2024 Act remains largely unenacted, and the mooted changes to adult incapacity law in Scotland, which were again mooted to be introduced, at least in bill form, at the end of the summer recess in 2025, remain notable largely for their absence. I think the changes to the kind of AWI landscape, the kind of critical thing is a real focus on one of the central pillars being the wishes and preferences of adults. And what we're finding, I think, or what we're probably finding, I think what we're probably being a little bit more proactive on now is actually looking to encourage clients to include their wishes and preferences, often by way of expression of wish alongside powers of attorney. And that might mean in relation to specific assets, but quite often it means in relation to care.
Once again, thank you to Pete and Callum for taking the time this afternoon. Really appreciate it.
Very welcome.
Thanks.